Good afternoon. Welcome to Legal Access. We get together this time each and every week to give you the opportunity to ask questions about different aspects of the law. Today we're going to be talking about criminal law. So if you have any questions about maybe the trial process, arrest process, DUI, drugs, anything to do with criminal law, make sure you give us a call here today. Phone number is on your screen, 843-848-8080. We'll get you on the air and get those questions answered. Here today to answer those questions on your panel. To my left, we have defense attorney Rick O'Neill.
Good afternoon, everybody.
And also from the solicitor's office, is it officially assistant solicitor?
Senior assistant solicitor.
I always get that wrong every time. Josh Halford. Hey, Josh.
Yeah, thanks for having me, Dave.
And Rick, in addition to being a defense attorney, what are some of the other things that you handle in your law firm?
We do workers' compensation and auto wrecks.
All right.
Basically personal injury.
All right. Phone number is on your screen, 843-848-8080. If you have any questions about criminal law, like I said, any aspect, whether it's a specific crime or whether it's something in the criminal justice system in general, whether it's bail, whether it's plea bargains, whether it's a jury selection, the jury process, any kind of question you might have in general, please give us a call here today. We can get those questions answered for you. I have kind of a generic question here. We had a big case here recently in the Horry County area that had to do with stalking amongst a married couple. What kind of, Josh, I guess from the solicitor standpoint, what kind of things do we have on the books here as far as laws against stalking your own wife?
Yeah, there's a number of things. Harassment, it can start in harassment and it can be a misdemeanor. And then as you continue that pattern of intentional intrusion into their personal life, it would have to be outside and above and beyond, your own household. If you're going to the job, the work, if you're tracking them, if you're continually, causing some type of emotional or mental distress. Typically we see that when couples are getting separated or are separated, even though they're still married. There can certainly be criminal charges there.
Who determines whether or not something goes above just, I want to know what my spouse is doing to go from there to being criminal? Yeah,
I think it really comes down to the victim's point of view, or the person that is being tracked or being their life being intruded into above and beyond what they would feel comfortable with.
And along those same lines, as far as order of protections are concerned, in both of your opinions, are orders of protection worthwhile?
Yeah, definitely. I mean, an order of protection gives you a stronger hand in the legal system. So if you have an order of protection, then the violation of that is a crime in and of itself. The order of protection also puts the person on notice, hey, I don't want this conduct. I'm not okay with it. You're going too far. And so then the police really have an idea of the crime that's being committed.
Rick, as a defense attorney, if you have a client and they say that I've just been arrested for quote unquote stalking my own wife, what kind of things are you going to look at as to whether or not that's a viable charge?
Well, what proof is there? Especially with a divorce litigation, if that's in play, there's always child custody, child visitation. They may be getting advice from their family law attorneys as to different strategies. So, sometimes a litigant will take those strategies too far and sort of set up the other spouse. So, you want to look at exactly what are the allegations and what proof is there that can be backed up, and could some of that proof have been manufactured by the other side?
We're talking about criminal law here today on Legal Access. Give us a call at 848-8080. We'd love to get you on the air if you have any kind of questions about any aspect of criminal law. Now, as far as drugs are concerned, now nationwide, the attitude towards drug arrest has been lessened a lot. I know it hasn't so much at all in South Carolina, but what is the attitude from a prosecution standpoint, Josh, as far as if somebody gets arrested for a small amount of marijuana, for example?
Small amounts of marijuana in South Carolina are still a crime, but the penalty you're going to face may be less. And so you're going to be arrested, you're going to be charged, you're going to have to go through the justice process, but what you might get is a fine or, a couple days, as opposed to where it used to be, you might serve a month or 2 months or years in jail for that amount.
Well, one thing about some of these minor crimes that people new to South Carolina don't understand is these minor misdemeanors, traffic tickets, even some city ordinance are all considered misdemeanors in South Carolina, which, sometimes when people are applying for different security clearances or immigration applications and so on, that comes up and they weren't aware. They just paid a fine on a city ordinance, for example, and now they're being denied this or that benefit from the government.
848-8080, that's our phone number here. Give us a call as we're talking about criminal law here today on Legal Access. I know that in a calendar there's only 52 weeks of the year, and I know that trying to jam in all of the criminal complaints into a 52-week month, or year rather, is an impossible thing to do. And I know that's one of the reasons that so many plea bargains are come to an agreement by every month and every day. As far as plea bargains are concerned, I know that some people go out there and they read them in the paper. They said, how does this person plead down and only got 2 years in prison for something that they consider to be pretty serious? When you make a plea bargain agreement, do you go to the victim or the victim's family and make sure that that's amenable to them before you offer that to a defendant?
There's always contact with the victims and the victim's family. Contact is attempted through not only the police on the front end, but by the bond hearing and then by our office as well. And so that contact is made. It's ultimately up to our office, though, what to offer. We like to contact them and let them know. We like to get their opinion. We want to hear from them and have them involved in the case. But it's ultimately our decision as the prosecutor of how the case will proceed. We do take victims' concerns and their input into account, but the ultimate decision does lie with us.
Rick, as a defense attorney, when do you look at a plea deal and say, hey, you need to take this?
Generally, if there's some evidence there, it's to avoid the risk of going to trial on a more serious charge, or maybe it's a felony and you've been offered a misdemeanor plea bargain. A lot of times I tell my clients, you really need to consider this. They may have a different opinion, and but there's that risk of going to trial and what they call the trial penalty. If you do take something to trial, especially in General Sessions Court, and are found guilty by a jury, you're definitely facing jail or prison.
All right, you mentioned bond, Josh. Now, as far as bonds are concerned, somebody might go in front of a judge and get reduced bond or own recognizance.
Yeah.
And what comes into the consideration when a judge either does give bond or doesn't give bond, or the amount?
There are two factors. It's flight risk and danger to the community. Now, there could be a third factor that's lumped into this danger to the community. That's, are you out on bond already? So is it a repeat offender? They've changed some of the bond statutes to allow for, if you're out on bond and you commit another crime, you might have to pay a cash bond in certain instances.
All right, before we run to break, we want to go to the phones here. We got Herbert in Bennettsville on the line with us. Hey, Herbert, thanks for calling in. What's your question today?
Yes, I would like to know how serious of a violation, or if it is a violation, for a lawyer to abandon his client, does not make a closing argument in a death penalty trial.
I think that's really not whether that would be a criminal law question. It's more of a ethical question. Attorneys do operate under attorney rules of procedure and conduct, and they have to give their best, zealously represent their client, but also ultimately in trial, the conduct of the trial and the strategy of the trial, a lot of that is left up to the attorney. Now, you always have to take your client's wishes in and discuss, this is one strategy, this is the pros, this is the con, and get their input, and they are strong input. Sometimes it's really up to the attorney whether a lot of the different strategies. Now, something as serious and such a big, substantial strategy as whether or not to give a closing argument, that may be something that someone would have to take a second look at.
Depends on what's going on. That might be grounds for appeal. Or what do they say? Didn't get a zealous defense on your part, so you might be able to look at it that way if that's what happened with somebody that you're aware of. All right, Herbert, thanks for calling in here today. We appreciate that. Again, before we go to break here, let's go to Levon in Myrtle Beach. Levon, thanks for calling in. What's on your mind today?
Oh yes, sir. I got stopped. I got stopped with an open container in the car, and also had a gun in the car pocket. And when the police stopped me, I had them pull up in the where my cousin had lived at. It was like a project, so I had pulled up in the project. Then I look up, see the blue light behind me. But I had an open container with a handgun that I took out the car park to get ready to walk in the house. Then I see the blue light behind me, so I stopped. And the guy said I was speeding, but he never gave me a speeding ticket. So I went to jail, and I stayed there 3 months, and he took my license from me, too, at the same time. So I stayed there 3 months, and I did time served. I'm trying to figure out how can I get my license back.
Getting the license back is an administrative procedure. Licenses, the DMV deals with those, and so they're the ones who have to decide whether you're going to get your license back or not. As far as the criminal forfeiture, depending on what you pled to, a gun or an open container isn't necessarily going to forfeit your license, to my understanding. But if there are other crimes that may have been involved, then they could have taken your license for that.
Where should you go next then in that case?
To get a license back, it's got to go to the DMV. They're the ones that issue and restrict and suspend licenses. They will see the crime on the record, and they might restrict or suspend the license, but they're the ones that deal administratively with granting licenses or not.
All right, Levon, thanks for calling in. Good luck on that. Our phone number is 848-8080. Going to run to a break here right now. When we get back, we would love to talk to you. Criminal law is our topic here today on Legal Access. Welcome back. It's Legal Access, brought to you by the Maguire Law Firm here on WMBF News. Our phone number is 843-848-8080 as we're talking about criminal law here today. Any questions about any specific crime that you want to know about? DUI, drugs, or the entire penal system here that we have? I almost said penal colony. We don't have a penal colony here, to the best of my knowledge. The trial process, if you want to have any kind of questions answered on that, of course, 848-8080 is the phone number. And Rick, a lot of people will watch, defense attorneys on various, big crime shows or whatever that is, and they'll see a defense attorney doing the best they can to get the defendant off on technicalities or whatever the case may be. People have the question, okay, if a defendant comes to you and you know that they're guilty on something, if they've admitted to you that they did what they're being charged with, is it incumbent on you to still give him a defense to try to get him off, or as a defense attorney, is it you legally bound to say, hey, he is guilty?
No, your duty, according to the lawyer's professional rules, is to be a zealous advocate for your client, give it your best, and it's really for the trier of fact in the court to decide whether there's enough evidence in the record for a conviction, whether they've proven their case. So,
all right.
Regardless of what your client tells you, you give it your best shot.
And also for you, Rick, what's your stance on putting the defendant on the stand during a trial?
I mean, I probably do it more often than a lot of defense attorneys. I think a jury likes to have a client look them in the eye and give them their side of the story and to judge their credibility. But in a lot of cases, probably more than half of the time, that doesn't happen, and you just let the government prove their case beyond a reasonable doubt.
Now, Josh, from your end, from a prosecution standpoint, I know that we here in Horry County and in the 15th Circuit, we've got some things to help move some of these cases along. I know like a drug court, DUI court, we have some things that if people have these offenses that they might be dealt with outside of a courtroom and get them through. Has that been pretty successful in getting some of the backlog taken care of?
It's been very successful. First-time offenders have pretrial intervention. That's a program where they go in, they do community service, they're maybe drug tested and pay some fines, and then if they complete that program, it's completely expunged from the record. We have conditional discharges for first-time drug offenses. They do a short term of probation, and if they complete that, the charge is then dismissed. We have drug court, and that's for people, they might have a long record, but they have a substance use disorder as well. So even if it's not a drug crime per se, if they're shoplifting over and over and over to get money to pay the drug dealer, we see that a lot, we'll put them in a treatment court or a drug court program. If they successfully complete that, we dismiss the charge and expunge that specific charge off their record. What we've found is that when people are given treatment over a long period of time, it can really change their lives. That's a benefit not just for them, that's a benefit for the police because they're not arresting that person again. That's a benefit for the victims because they're not being victimized again. It's a benefit for the community. So these programs are really life-changing for everybody involved.
Do you have any kind of statistics on the recidivism rate of some of the people who have gone through these programs?
Yeah, for the people that graduate our treatment court at a 5-year outlook past the graduation, we're seeing 90%, around 90% are not reoffending. And that could be people with an average of 15 to 20 convictions prior to coming in.
Yeah, just breaking the cycle of behavior and bad habits and addictions gives people a new lease on life and lets them get out of the criminal justice system and start a new life. The programs have really been successful.
Fantastic. Our phone number is on your screen. It's 843-848-8080s. We're talking about criminal law today. And I'll get phone calls on the radio station. They'll ask about immigration. Now, as far as local authorities are concerned, if they arrested somebody who is undocumented, do they have to go through and contact somebody with ICE or a federal agency, or is that something that can be handled locally?
It's not handled locally as far as the removal process or the ICE process, but when they are booked in to the jail, then that's flagged.
One of the things we talk about in criminal law is DUI, and Rick, I'll go ahead and throw you the softball question. We do for that all the time. If you get pulled over for DUI, should you blow the breathalyzer or not?
I mean, the general advice most DUI defense attorneys give is don't. There is a new revision to the DUI law that just went into effect about a month ago, where there's increased penalties that if you do not take the breath test and that's upheld at a DMV hearing, you're going to be required to get an IID installed on your vehicle or maybe all of your vehicles. There's expense to that, and actually that program statistically has been shown to also alter people's behavior, and when it's put into effect, the DUI rates and the DUI injury-related
Right.
DUIs also go down.
And just to explain, IID is the ignition interlock device. That's where you have the breathalyzer attached to your car and the ignition won't start if you have any kind of alcohol on your breath.
And the ones that are mandated in South Carolina have a very high definition camera, color camera, so there's no way around it. And if you blow with more than just a little bit of alcohol,
Right.
you're not going to be able to drive your car. And that's going to be also reported.
Right. And with the camera there, that keeps your passenger from doing it for you. So.
Right.
All right, let's go to something more mundane as far as jury duty is concerned. A lot of people, if they get a jury duty notice in their mailbox, just get all upset because it's like, oh my gosh, I got to do that. Is jury duty that bad?
No, most of the time, I mean, most of the time they call, maybe 300 people in and, you narrow it down to a pool of 40 and then 12 to 14 get accepted or picked for the jury duty. So if you have to sit in a trial, I mean, in South Carolina, at least in this area, even a murder trial is going to take a week.
Yeah.
It's not going to take, 5 months like you can see in some of these other states. So it's really not that bad. And once you've served, you get an exemption for 3 years.
And before we go to break here, one of the reasons they're kind of short in South Carolina is that the jury selection process is not like it is in other states. What kind of say do you guys have as far as selecting the juries?
We get to know where they work. We get to know where their spouse works. We can ask limited questions, voir dire, very limited questions. Are they affiliated with law enforcement? Are they supportive of victims advocates? Have they been convicted of a crime? Have family members been convicted of a crime? do they know anything about this specific crime? But we're pretty limited in the questions and the things that we get to ask and get into.
I tell you what, we're going to run to a break here real quick. When we get back, we'd love to get you on the air. If you have any questions about criminal law, that's our topic here today. 843-848-8080. We'll be back in about 90 seconds right here on Legal Access. Welcome back. It's Legal Access. We're talking about criminal law here today. Again, our phone lines are open. If you have any last-minute calls to get in, we'd love to hear from you. 843-848-8080 is our phone number. We do have Gretchen on the line with us right now in Conway. Hi, Gretchen. Thanks for hanging through the break. What's your question today?
Oh, yes. I just wondered how to proceed with an issue. My father was enrolled in a hospice when he was not terminally ill and was given multiple drugs that were unnecessary, and Medicare was charged thousands and thousands of dollars for a few months before my father's death when he was not terminally ill. So he was put on hospice actually fraudulently, and I wondered how to proceed and what advice you might give me to correct this problem. He has died as a result of these multiple toxic drugs that were not necessary.
Well, anytime, especially the federal government is involved, most all the agencies have hotlines that you can call and report either over the phone or online if you think you suspect there was some type of fraudulent activity where the government was billed for something. What you're talking about, I think, would be more of a civil matter. You may want to talk to a medical negligence lawyer. Usually those type of lawyers just specialize in that very narrow field.
Right.
To see if there was, anything that can be proven, a viable case. Those cases are generally not easy to prove because the public and juries give a large discretion to doctors to make decisions on what's best for the patient.
Yeah. Yeah, that, like you said, Rick, I think would fall under medical malpractice. So if you can find somebody who specializes in that. In addition to that, as far as the fraud is concerned, obviously that's multifaceted on that as to where that might go to Medicare and the insurance companies and the hospital itself as well. So a lot of phone calls in front of you, and we're sorry for your loss, Gretchen. So thanks for calling. Appreciate that. But good luck in your endeavors here. Now let's go back to DUIs for just 1 second. Roadside sobriety tests. We already talked about the breathalyzer, and you can refuse a breathalyzer. Of course, when you do, you'll automatically lose your license for 6 months. As far as roadside sobriety tests, are those refusable as well?
Yeah, there's no legal requirement that you participate in even discussion with the officer about your drinking or whether you've had anything to drink or how much, and definitely there's no legal requirement that you volunteer to participate in any of these roadside sobriety tests. It's a tough decision. Sometimes it may let you be on your way, but on the other hand, if you have the inkling that the officer is pursuing a DUI investigation, I think it's best just to, decline and just keep your mouth shut.
Well, I read the other day that there's a state somewhere, I want to say it's like North Dakota, Minnesota, somewhere that's actually they passed a law where the police officer can't come up to you and roll down the window and say, hey, do you know why I pulled you over here today? Because you're admitting guilt by just saying, yes, I was speeding, or yes, I was weaving all over the place, or whatever. So anything that comes out of your mouth. So at least apparently in one state that's illegal to even ask, hey, you know why I pulled you over? So that's a little bit of an interesting take.
Yeah, so a lot of these libertarian-leaning groups, you see all the videos on YouTube and the different social media where they get confrontational with the police. I generally think probably the best thing to do is just be polite, cooperative, but always keep your rights in mind and don't give up any of your rights.
Now, Josh, as a prosecutor, we talked about some of the roadside sobriety tests and DUI and breathalyzers and stuff like that. How vital are those pieces of evidence to you as far as prosecution goes?
It's a part of the case, and so how they're driving, are they weaving, are they running through stop signs, are they speeding? Those are some of the things that are looked at. How they appear on camera at the site is a part of the evidence. The breath test is part of the evidence. So it's all pieces.
All right, that's all the time we have here for you today on Legal Access. Next week, we won't be here. Check your calendars. The 4th of July, we'll be taking that off as well. We'll see you next time, though, here on Legal Access on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information